Welcome back to The Explainer. Joining me is Attorney Edwin Lacierda, a constitutional law professor at the FEU Institute of Law. And this is how he's guesting tonight. He's going to take off his hat as Noynoy Aquino's spokesman for the duration of this show. Okay, Edwin, let me ask you. Congress is due to meet tomorrow in an unprecedented joint session. What questions or what sort of legal arguments are going to be confronting Congress?
Basically, the factual basis for the declaration of martial law. You would see there that based on the report submitted by the President last night, and which you amply pointed out was really bare, they will discuss there the validity of the calling for the martial law. In the report itself, it shows the massing of forces, it shows the offices, government offices being shut down, but does it really justify or equate to an actual rebellion as envisioned by the constitutional commissioners? In the 1986 Constitutional Commission, the deliberations were very clear. It must be an actual rebellion. In fact, Father Bernas cited an example of Manila Hotel, when former Senator Arturo Tolentino and some armed forces, retired generals, took over Manila Hotel.
And Tolentino proclaimed himself acting president.
As what you call it, the cry of Balintawak. He said that he proclaimed himself as president, and yet President Aquino did not declare martial law because in the understanding of Father Bernas, there was no public safety requirement there. So since the public was safe, you need not, and even if there was an actual rebellion, for as long as public safety is not endangered, there is no need to call for a martial law.
Well, what we have is a 20-page report which our viewers can find online. It's in the Inquirer website and everywhere practically. Now, based on this document that you've seen, is this how are members of Congress going to approach it? How will they verify anything in this document?
Well, you know, it's difficult. For the congressman, I think they'll have to take it at face value. But this morning, when Secretary Puno was explaining the whole thing, there was one thing very, very interesting I observed, and that was clearly absent from the report itself. It was his insistence on the removal of allegiance by the forces. Nowhere in the report do they mention about these forces removing their allegiance from the Republic of the Philippines.
Now, are members of Congress bound only to stick to what the President herself has submitted as her reasons, or can they take something like a FOCAP press con and that sort of thing?
It's possible that they can take judicial notice of the FOCAP press con this morning, but it's essentially what I saw was that Secretary Puno felt that the report itself was deficient. The massing of arms, the presence of ordnance, do not in and of themselves constitute rebellion. It has to be rising up public and taking arms. The closest, in fact, I think, would be sedition. In fact, in the report itself, if you remember, they said that government offices were closed. The local civil register of Maguindanao refused to issue death certificates for the massacre victims upon orders allegedly of Andala Potuan Sr.
Let me interrupt you here and run down what are the allegations made by the government to justify their proclamation of martial law. Among the things they pointed out was, let's just focus on three. The first was that the courts, the legal system was not functioning. They could not get death certificates. They could not get warrants of arrest. They couldn't even get judges to try the courts. Are these grounds for rebellion?
Well, no, it's not. It's not. When you speak of a martial law, in fact, this is again stated in the deliberations of the Constitutional Commission, martial law must be declared in a theater of war, where actual war is going on. And this is based on American jurisprudence where we took it from. And there clearly is no theater of war. Now, precisely, the fact that allegedly the courts are not functioning has been debunked by Midas Marquez himself. In fact, they say that you could easily avail of search warrants and warrants of arrest can be availed elsewhere, and
this was the spokesman of the Supreme Court.
They are applicable to all. You can enforce them anywhere, any part of the Philippines.
Okay. The next point that was raised was that while there had not been at that point actual confrontation between the forces of the government and the CVs and the CAFGUs under the Ampatuans, that they were massing and building alliances that could be interpreted as they're being poised to rebel or having basically left the chain of command.
But there's a remedy already, Manolo, for that. In fact, that's the first action. The powers of the president in terms of rebellion, invasion, or lawless violence are graduated. In the case you have perhaps the massing of forces, that's not even lawless violence. No violence has yet been committed, and therefore the first power the president should have done, and she has done, was to call out the armed forces. That
under
alone,
the state of emergency, that's
no,
what
no.
she did.
Yes, when there is lawless violence, when she feels that there's lawless violence, when she feels there's a rebellion or invasion going on, those three grounds in and of themselves, the president can immediately call out the armed forces without having to declare, as you put it a while ago, suspending the read and imposing martial law. If the president feels, or if the armed forces can contain whatever lawless violence there is, that's sufficient. The problem is there is not even lawless violence obtaining in Maguindanao right now. There's merely a threat, as we call it, the imminent danger of whatever they want to picture.
What about the argument of the government that basically civil government had ceased to function, that nothing was going on, and that this is tantamount to withdrawing obedience or allegiance to the government?
It's not, you cannot equate it that way. In fact, in the diary of Jess Dureza, it's the armed forces who took over the offices right now. Whether they would like to work or not, whether they were forced to, in fact, that's a ground for sedition. When Andal Apotuan told them, don't report for work, that's a ground for sedition, not rebellion. Okay. And so it's wondering for us to see why they called it rebellion.
And finally, there was the point where they discovered these warehouse full of, there were vehicles, there was a pickup truck painted in PNP colors, and Secretary Puno said, well, you know, when you start masquerading a vehicle around as a government vehicle, it's setting up your own army, and setting up your own army is ipso facto withdrawal of allegiance. You're setting up a rival government.
Well, you know, if you're going to set up a rebel government, it should have been a Ampatuan something, not PNP. Also, it's also punishable under another part of the revised penal code. It's usurpation of public authority, which in and of itself does not mean that you are seceding from the government. They just prefer to usurp their own authority, but not necessarily calling themselves as rebellion. I think one thing here that's clearly absent is really your so-called cry of balintawak. Ayoko na. We're setting up our own government. The worst in the report that I saw was a statement of some Amputuan who said, patayan kung patayan, which is not practically a call to secede.
But there will be the other argument, of course, that regardless of the opinions of the constitutional commissioners when they were drafting this, at the end of the day, we are bound by what the Constitution explicitly says. Now, the Supreme Court basically said, the government basically claims they may have never explicitly said it, but implied in all their actions is a rebellion. So, your last statement on this point.
Well, basically, the Supreme Court has the power to review the factual basis. This is an exemption to the doctrine that the Supreme Court is not a trier of facts. We have our last resort. The Supreme Court can review it factually, and if those bases do not hold water, then the Supreme Court can easily revoke the proclamation.
Follow-up question, if the President lifts the proclamation before the Supreme Court can reach a decision, what happens?
Then martial law is over, the Supreme Court will decline and will call it as moot and academic.
Okay, thanks very much, Edwin. I'm Manolo Quezon, and this has been The Explainer.